Hello, my name's Eric Hanscom. I'm the managing attorney at Intercontinental IP. We're a Carlsbad-based law firm. We do patents, trademarks, and copyrights. The next type of intellectual property I want to go over is trademarks. Now, again, with patents, the goal is to protect an idea or a shape to the point where if you're a scientist or an R&D person or an inventor, it's going to be worth your while to put your time into inventing and trying to improve the lives of people, at least across the U.S., by having an invention that makes it easier to crack nuts, or perhaps a better bubble-blowing toy or a better pair of surf trunks. The goal of trademark law, on the other hand, is to prevent consumer confusion so that when a consumer buys a product, they know the company that's making it. So the goal of trademark law is different than the goal of patent law. At the same time, trademarks are examined also at the U.S. Patent and Trademark Office, and they go through a similar application and examination process. So one of the differences, if you're looking across the row that begins with trademarks, is the cost. Most of our clients are in and out for under $2,000, including preparation, filing, and prosecution of the trademarks. Now, these are the clients that have the trademark search done and pick a unique name. We're going to be going over later on in this course what makes for a good trademark name, what makes for a bad trademark name. If you pick something that's merely descriptive of the products you're selling, you're probably looking more to $4,000 or $5,000 trademark application and prosecution. You may not end up with a very strong trademark at the end of it. So pick your name carefully, have the trademark search done. You're probably in and out for under $2,000. Trademarks, as opposed to patents, do not have a natural expiration date, which makes sense. I mean, obviously, if you're Coca-Cola or Ford Motor Company or Microsoft, it's going to be kind of hard for you to take a lot of pride in turning out a good product if you know you're going to lose your name in 5 years and everybody can call their particular product by your brand. And again, you just have to go over to some of the countries that don't enforce intellectual property and see what it's like walking down the streets and being offered Rolex watches that really look like real Rolex watches, you know, for 20 bucks. Trademarks are usually examined between 4 and 7 months after the application is submitted. Again, if you've picked your name well, they often come back with a minimal amount of extra work. However, even in a perfect application that goes right through the U.S. Patent and Trademark Office, there are a number of documents that they send out that have to be reviewed. You can review those yourself and hope you do a good job, or you can pay a patent attorney to do it for you. Usually, again, with a well thought out name, these aren't huge legal bills, but just be aware once you file the application, the next step is not automatically that the issued trademark is mailed back to you, because there often are USPTO office actions and notices of publication, notices of allowance, things like that, that somebody does have to review. So unlike patents, trademarks can be extended for an indefinite number of years. Your first renewal fees are due at year 5, and then every 9 years after the initial issuance of the trademark, you have additional renewal fees due. So basically 5, 9, 19, 29, 39, 49, 59. The renewal fees are not huge, so that's good. It doesn't cost you an arm and a leg to keep a trademark alive. However, you do have to submit proof that you're still using the trademark in order to be allowed to renew your trademark. And failure to use your trademark can result in your losing it. What are some common things to trademark? Well, the most common thing is the name of your product, the name of your business, but you can also trademark the logo. If you have some sort of a mascot, you can trademark the mascot. Any kind of a slogan, any graphical elements. If you happen to use a particular font in your name that you want to keep, you may be able to trademark that as well. There are 2 types of trademark applications you can file. One is stylized, which means that you incorporate things like colors and shapes and fonts and things like that. And the other is standard. And with a standard trademark, you're just filing on the name. Nothing fancy, nothing extra. With stylized, you're trying to bring in the other elements. So when do you file for stylized and when do you file for standard? My advice to people is if they think they're going to keep their logo for more than 5 years and it has some really unique elements, unique colors or something like that, my advice is to file stylized. If on the other hand you think you're going to change things a lot, you should probably just go with a standard application.